Thank you, John, and welcome to our panel, Putting Your Money Where Your Mouth Is, the new assaults on campaign speech. Money has long been an issue in American politics, going back to the time of Andrew Jackson. Congress passed the first campaign finance law in 1867, then the Tillman Act in 1907, and then a Federal Corrupt Practices Act in 1910. The modern era began in 1976 in the landmark case of Buckley v. Vallejo. And by 2014, when the Supreme Court decided McCutcheon v. FEC, the world of politics and speech had been turned upside down. Liberal groups that had once opposed government regulation of speech denounced today's opponents of regulation. The debate continues. Indeed, we've recently witnessed United States senators in a spectacle on the floor of the Senate pushing to amend the First Amendment. The questions are profound. Is it true that money is not speech? Are corporations people? Have liberals abandoned their prior commitment to free speech? Who really benefits from government regulation? How much speech are the American people willing to tolerate during election campaigns? Should some speech be banned during those campaigns? Who can speak, and how much can they speak? And what's next? What are the coming cases? Where is the court heading? And what explains the vitriolic rage against some of those, like Floyd Abrams and former ACLU President Nadine Swanson, who oppose government regulation? Our event today revolves around a remarkable case and a remarkable book, When Money Speaks, the McCutcheon Decision, Campaign Finance Laws, and the First Amendment. We have a stellar panel to explore these issues. Author and free speech scholar Ronald Collins will discuss his book and how it came to be. Erin Murphy, who argued the McCutcheon case, will share her insider's perspective. Floyd Abrams is simply one of the greatest figures in the 200-year history of the First Amendment. And there's no keener observer of the court than our moderator, New York Times correspondent Adam Liptak. I'll briefly introduce each panelist and then turn the program over to them. Ronald Collins is the Harold Scheffelman Scholar at the University of Washington Law School, where he teaches constitutional law. He was a Supreme Court fellow under Chief Justice Warren Burger and law clerk to Oregon Supreme Court Justice Hans Linde. He's the books editor at SCOTUS blog and writes a much-read First Amendment news column for the Concurring Opinions blog. Collins is the author or co-author or editor of 9 books, including books on Justice Holmes, a great book about Floyd Abrams, books on Lenny Bruce, Allen Ginsberg, and Jack Kerouac. Last year, he also published a book entitled On Dissent. His latest book, with David Scover, is, of course, When Money Speaks, which is a brilliant analysis not only of the case, but of the entire history of campaign speech regulation. And he published this book a mere 30 hours after the case was decided by the Supreme Court. Ron has written more than 70 scholarly articles for the Harvard Law Review, Stanford and Michigan Law Review, and the Supreme Court Review. And in 2003, he led a successful campaign to get a posthumous pardon for comedian Lenny Bruce. The following year, he received the Hugh Hefner First Amendment Award, and in 2010, he was a fellow in residence at the Norman Mailer Writers Colony in Provincetown, Massachusetts. And in 2011, he received the Supreme Court Fellows Administration of Justice Award in recognition of his scholarly and professional achievements. Erin Murphy is a partner at Bancroft PLLC. Her practice focuses on the Supreme Court, appellate, and constitutional litigation. She's worked on numerous significant matters in the Supreme Court and successfully argued McCutcheon v. FEC, in which the court held the federal aggregate limits on campaign contributions unconstitutional. She has also argued before the U.S. Courts of Appeal on other important constitutional questions. She has briefed several high-profile Supreme Court cases, such as the landmark challenge to the Affordable Care Act, Bond v. United States, and American Broadcasting Companies versus Aereo. And she's worked on a wide range of civil and criminal procedures in the Courts of Appeals. Before joining Bancroft, she served as the law clerk to the Chief Justice of the United States, John Roberts, and Judge Diane Sykes of the U.S. Court of Appeals in the Seventh Circuit. Between clerkships, she served as a Bristow Fellow in the Office of the Solicitor General, and afterwards she worked in the appellate practice of King and Spalding. And she's been profiled widely in media across the nation and around the world for her work on McCutcheon. She graduated magna cum laude from Georgetown Law School, where she served as managing editor of the Georgetown Law Journal's annual review of criminal procedure, and she earned her undergraduate degree from Northwestern University's Medill School of Journalism. Floyd Abrams is a partner in the law firm of Cahill, Gordon, and Rindell in New York City, and by all accounts, he's the preeminent First Amendment lawyer in the nation. The late Senator Daniel Patrick Moynihan called him the most significant First Amendment lawyer of our age. He has a national trial and appellate practice and extensive experience in high visibility matters, often involving the First Amendment, securities litigation, intellectual property, public policy, and regulatory issues. He's argued frequently in the Supreme Court in cases raising issues as diverse as the scope of the First Amendment, the interpretation of ERISA, the nature of broadcast regulation, the impact of copyright law, and the continuing viability of the Miranda rule. He was co-counsel with Professor Alex Bickel in the landmark Pentagon Papers case. Notably, he prevailed in his argument before the Supreme Court on behalf of Senator Mitch McConnell as amicus curiae, defending the rights of corporations and unions to speak publicly about politics and elections in Citizens United versus FEC. His clients have included McGraw-Hill Companies, Standard & Poor's, the New York Times and the Pentagon Papers case, and various networks, The Nation, Reader's Digest, Hearst, and many more. In November 2011, Yale Law School announced the formation of the Floyd Abrams Institute for Freedom of Expression, whose mission is to promote free speech, scholarship, and law reform on emerging questions concerning traditional and new media. For 15 years, he's been the William J. Brennan Visiting Professor of First Amendment Law at Columbia Graduate School of Journalism. And he's also been a visiting lecturer at Yale Law School and Columbia Law School. Our moderator, Adam Liptak, covers the Supreme Court for the New York Times. Liptak's columns on legal affairs, Sidebar, appears every other Tuesday. A graduate of Yale College and Yale Law School, Liptak practiced law at a large New York City law firm in the legal department of the New York Times Company, and then joined the paper's news staff in 2002. Adam was a finalist for the Pulitzer Prize in Explanatory Reporting in 2009 for American Exception, a series of articles examining ways in which the American legal system differs from those of other developed nations. He received the 2010 Scripps Howard Award for Washington reporting for a 5-part series on the Roberts Court. He was awarded Hofstra University's Presidential Medal and an honorary doctorate from Stetson University College of Law. Liptak is the author of To Have and Uphold, the Supreme Court and the Battle for Same-Sex Marriage. His journalism has appeared in The New Yorker, Vanity Fair, Business Week, and Rolling Stone, and he's published articles in several law reviews. And he's also taught as a visiting lecturer at University of Chicago, and he's taught courses at Columbia, USC, UCLA, and Yale. Before I turn the panel over to Adam to moderate, I'll mention we're going to do something a little different today. Each of the panelists is not going to begin with the usual 5 or 7 minute opening statement. Instead, they're going to plunge right into the conversation so you can get a sense of what it might be like to sit at a table and eavesdrop with them as they sit together and discuss a First Amendment case. So, Adam?
Thank you, James.
I turn it over to you.
Our format is meant to incite robust, uninhibited, and wide-open discussion. I want to say one thing about the subtitle of our panel today, the new assaults on campaign speech. I come to you as an emissary from the real world. Campaign speech is in pretty good shape, thanks in large parts to the efforts of our panelists. Campaign finance law, as you know, gets pretty arcane pretty fast, and I'd like to keep this at a level of generality, which is how the American public perceives it. This is probably the most timely and divisive issue in American law and politics, and I want to explore why it is that we're so divided about something that you might think the First Amendment was meant to protect. You know, the First Amendment, by most accounts, is meant to protect speech about politics. The question in the Citizens United case was whether you could make it a crime to distribute a documentary about a politician. And it's somewhat surprising that that should be so divisive. So let me start by asking Floyd a question. The large New York City law firm James referred to was Floyd's firm, Cahill, Gordon, and Rindell. I worked there a long time ago. And I've known Floyd for a long time, and I think of you, Floyd, as a liberal. Why is it that you find yourself isolated from some of your old friends on this issue?
Well, I think it's because they care more about their political liberalism than about the First Amendment. I think it's because